So, yeah, please, Lordship. Lordship, I'd like to mention item number 12 to 15, Lordship. If I can be accommodated for tomorrow, Lordship.
12 to 15.
Lordship. I have taken consent from the other party also, Lordship.
Okay. Do we have a bench tomorrow, division bench?
Yes, Lordship, we can have a Lordship.
10 to 12 to 15.
12 to 15, Lordship.
Okay. Both sides are represented on the prayer made by Mr. S. Tapin, Government Advocate, list on 12/11/2025.
All right.
Lordship.
Yeah.
I'd like to mention item number 3, Lordship.
Item number 3.
Yes, Lordship. Here I was directed to file the encroachers list, Lordship. We need some more time to do that.
How much?
Lordship, 3 weeks time.
You have to receive instructions from which department?
Deputy Commissioner, Lordship, Basar.
For affidavit.
Yes, Lordship.
In fact,
No,
Lordship,
affidavit I have filed, but then
Lordship, on 10/6/2025, direction is issued to the Deputy Commissioner to conduct a survey in respect of the
encroachers.
encroachers and list to be prepared and submitted before this honorable.
Just give that file, item 3.
We are yet to do that, Lordship.
What should we do to create some interest in the Deputy Commissioner to do work? Suggest something.
Lordship.
16/9.
We'll say that if on the next date you don't file the report, then it will be present through video conferencing. Now we have this video conferencing, he can always attend.
Actually, encroachers list, Lordship, they have sent, but this is not sufficient. That was what the Honorable Court has observed last occasion. So, Lordship, he has been asked to do the resurvey again, and the encroachers has to be
Which is that order?
properly, yes.
Order, Lordship, 10/6/2025.
Hmm?
Order, said order was passed on 10/6, Lordship.
10,
10/6.
6. You see that record? Acha. Okay. Where is the video?
La survey la identified the camp. Itu ang montoken. Survey itu.
Last para, Lordship.
How much government land is there?
Government land, Lordship, as per their notification, the total area is 490 acres.
490 acres.
90 acres.
by Mr. K. Lonan, Learned Counsel for the petitioner. Ms. G. Ate, Learned Additional Senior Government Advocate, praised for further 3 weeks' time
Lordship,
for compliance of the order dated 10/6/2025. Next para, on a query of the court as to what is the area of the government land which is alleged to be under encroachment, the Learned Counsel for the petitioner has submitted that the government land is around 490
Yes.
acres.
Acres.
acres also. Acres, no. 8 notification, district notification.
Acres as per notification. Next para. But an order dated 10/6/2025. This court had observed that in the affidavit in opposition filed by respondent numbers 4, 5, and 6, it indicates that there are some encroachment of the government land in Tirbin, TIR, BIN, Tirbin Township. And that for identification of other encroachments, the department would require a reasonable time. So accordingly, 3 weeks' time was granted to identify the encroachment. Full stop. Almost 6 months has, 5 months has lapsed from the order dated 10/6/2025. And the said order has not been complied with. Next para, under the circumstances, while allowing the prayer for adjournment, the court is inclined to observe that on the next date of listing, if the survey is not completed, then the deputy commissioner, Leparada, LEPARADA, within bracket respond number 4, extra assistant commissioner, chief estate officer, within bracket, Leparada, within bracket respond number 5, and this district land revenue and settlement officer, circle Tirbin, TIRBIN, district Leparada, within bracket respond number 6, shall produce the records of day-to-day activities taken up for the survey of the government land to find out to identify the encroachers. Full stop. Moreover, if the affidavit is not filed, the deputy commissioner, Leparada, within bracket respond number 4, shall be present in the proceedings through video conferencing. And to be prepared with the records to answer the queries of the court. Next, para the learned additional senior government advocate shall transmit a copy of this order to the deputy commissioner, Leparada, within bracket respond number 4, putting to notice post of the said authority, command receipt of a copy of the order shall also transmit a copy thereof to the respond numbers 5 and 6. Next para. The affidavit shall be filed at least 1 day prior to the next date of listing. Next para, list on 8/12/2025. We are giving you more than your desired time.
Lordship, this would be additional affidavit. Main affidavit has already been filed.
Okay. That affidavit, make it additional affidavit.
Lordship. Much obliged.
Deeply obliged.
My lord, counsel for the respondent side, with the consent of other parties, who wish to mention item number 8 and 9.
8 and 9.
My lord, the matter may be adjourned for today and may be scheduled for 27th of this month, my lord.
Connected appeals, both are.
Yes, my lord. What are connected cases?
Okay. Both sides are represented on the prayer made by Mr.
G.R. Romching,
G.R.
Romching, my lord.
Launching. Learned counsel for,
I'm for the appellant in item number 9.
you are counsel for,
Counsel for Jyoti Jungluju. On behalf of Jyoti Jungluju,
okay, and counsel appearing on behalf of
victim, my lord.
Zongluju, counsel for the victim. The matter stands adjourned today. List on 27/11/2025. You see all sides are represented, huh?
Much obliged.
May I please, my lord? My lord, I beg to mention item number 10, my lord. My lord, I've just been informed that PP, Mr. G. Tado is not well today, my lord. Therefore, my lord, the matter may be taken up after a week.
Okay, you have informed the other side. This is an amicus curiae appointed.
Yes, my lord.
Okay. Both sides are
Item
represented.
number
Item
10.
10. Both sides are
You like
represented
that.
on the prayer made by Miss
M. Karbak.
M. Karbak, learned counsel for the appellant. Matter stands adjourned today. List after
1 week, my lord.
a week.
Deeply obliged.
Item number 1.
Wait, please, Lordship. But this PIL is directed against the decision of the Deputy Commissioner by which the lone post of mayor of the Itanagar Municipal Corporation has been reserved for women without authority of law and exceeding his jurisdiction, my lord. Now, my lord, may I
But
just
there
take,
is a 33% reservation.
my lord?
There is a 33% reservation.
Yes. My lord, there are two provisions which governs the
We must promote the empowerment of the women. Empowerment of women must be promoted.
that is there, my lord, but then it should be as per law. Well, there are, for the purpose of reserving this post of mayor or chairperson of the municipalities, there are two provisions, my lord. May I have, my lord,
What is the
I
interest
have
of this
extracted,
person? What is the interest of this person? Who is he?
my lord, I have no personal interest in this,
Let
but
the
then,
people who are elected think about it. If you have no plan to stand in the elections, you have no business whoever is leading us.
my lord, in my application in paragraph 1 and 2, I have explained why I am before this honorable court.
No. It's just a ego. He doesn't want women to lead him.
No, my lord, it is not that the case, my lord.
Otherwise, you see why he is interested. Whether the next chief minister would be a what do you call women? The president of India is women.
My lord,
Sorry, I'm a bit.
my lord.
Not the same. The president of India is women. We are proud to be led by her.
Lord, what I am interested is that there are certain norms and laws in a democratic country, and constitutional provisions has to be followed. My lord, I am just highlighting that this is totally in violation of the constitutional provisions. My lord, may I just,
If it was wrong, somebody would have raised it in the assembly. No questions in the assembly on that.
my lord, that is for the legislature, because that is why they have failed to do it.
So the representatives of the people, they don't want it. They want the women to be there. But what is the law? Tell us the law.
My lord, anyway, my lord, may I just take a lordship to annexure 1? This is I have just extract the constitutional provisions of the Constitution of India
But have you seen the constitution? Is there not a bar to take up the matters with regard to reservations in the chair?
My lord, there are certain procedures to be followed, and that procedure has not been followed. There are two provisions, my lord. One is in Constitution of India, one is in the Municipal Act. My lord, at annex page, my lord, Article 243T.
243
T.
T.
Otherwise, it's there.
Yes.
May I read, my lord? Seats shall be reserved for the scheduled caste and scheduled tribes in every municipalities of the, and the numbers of seats so reserved shall be bear as nearly as may be the same proportion to the total number of seats to be filled by direct election in that municipality as the population of the scheduled caste and scheduled or in the municipal areas or of the scheduled tribes.
Come to 4 directly. The office
Yes,
of
4.
chairperson
Let
of
us come to the
municipality
4.
shall be reserved for
The office of chairperson of the municipal shall be reserved for the scheduled caste, the scheduled tribes and women in such manner as the legislature of the state may by law provide. Now, my lord, there is another provisions. Arunachal Pradesh Municipal Corporation Act, my lord, 2019, my lord, at page, next page, my lord, Annex 2. And it is provided under Section 53, my lord. Proviso, my lord. Section 53, proviso. My lord, may I just read the entire provisions?
which one?
The corporation shall be at its first meeting and thereafter at the expiration of every 2 and finally half year, elect one of the councillors to be the chairperson to be known as the mayor and another councillor to be the deputy mayor of the corporation, provided, my lord, here, that the office of the mayor shall be reserved for the Arunachal Pradesh scheduled tribes women by rotation or by lots in the manner prescribed, my lord. Now, my lord, I have wrote a letter to the department at Annex 3, my lord. Next page, my lord. This is addressed to me. Subject clarification on the request for information regarding notification or rules prescribing the manner of reservation.
This Municipal Corporation Act is in which volume? That APMC Act 2019 will be in which volume?
I think with the latest 13 or 14 volume. No, my lord, these two procedural provisions in this act provides that the manner has to be prescribed. Now, in Annex 3, my lord, I have approached the director, urban local bodies.
No, but 53 proviso says mayor shall be reserved for scheduled tribe women.
Subject to the manner prescribed, my lord. Now, my lord, may I just take you to Annex 3, my lord?
Rotation.
Annex 3, my lord.
So rotation is for members. For chairman, there is reservation for 5 years.
By lots. Okay. Surprise.
Will be just a moment. What is the amendment brought out in 2019 in that Municipal Corporation Act by which reservation for post of women is extended for 5 years? Where is that?
I think that is 2021. The period has been enhanced to five years,
Yes.
tenure.
Where is that amendment?
I think it is in volume 3. Now, my lord, in the meantime, my lord, may I just proceed, my lord?
No, there's a reason why we have stopped here.
Yes.
The issue is that by way of an amendment, this has been brought in. That amendment, we did not notice earlier that it was under challenge. If that is not there, there's no point hearing the matter. It has been done by way of an amendment to the Arunachal Pradesh
My
Municipal
lord,
Corporation.
not in nowhere through amendment or through any executive order or any
Yes, yes, it
notification,
is. It is.
nothing has been prescribed, my lord.
Yes, yes, it is. Page 21. It says B, post of mayor, serial number 1, 5 years, remarks reserved for women under section 553 1 APMC Act, read with so-and-so, Amendment Act for information. So there's a amendment to the provision. It's not justiciable then. But then you will be hit by the Article 243, which says no court shall examine the issue of reservation.
Uh,
Mr. Chairperson, tenure था 2.5 years का, 21 amendment से 5 years की है, वो बताइए.
that manner has to be prescribed.
Manner is prescribed. This 21 is the manner. Women of Indian origin have been in space for the highest number of days. Mr. Patil, women are very strong. You search your mobile. You have a mobile, search it. The lady to fall from the greatest height. Find out person falling from greatest height. You will find a lady's name will come up. She was an air hostess. She fell down from the aircraft from 33,000 feet and lived with some injuries, but she lived. She completed her 50 years of that fall, and after that she died. So they are very strong. Why you don't want to be led by a woman?
This section 53
Yes.
talks only about there has to be reservation, but then in a manner prescribed. So
So you see that
the manner has not been
intimation-
prescribed.
that's
That is my case, my lord.
The intimation has been given. You see,
There is reservation system is there, my lord, but then manner has to be prescribed by the legislature.
you have the copy of the act with you?
Which
The,
2019,
Municipal Corporation Act,
2019, my lord.
2019.
Yes.
You
I
have a
have.
copy? Please pass it on. Please, because we wanted to see section 15.2. 15.2.
Yes, my lord. I have annexed that in my
You've got it, Mr.
petition.
Tiwari.
My lord, this
Mr.
15,
Tiwari, you have got it. You have got it.
That's Visna Volovic,
Ah,
Serbian,
Serbian.
33,330 feet,
Yes.
flight attendant. It's a miracle, they say. Unbelievable. Everything is unbelievable.
No, women present in the courtroom, women lawyers, they would be happy at how strong they are.
But they should not jump.
No, only, you see, she also did not jump, but she lived.
I'm amazed at another miracle. How come your lordship knows all this and I miss out?
No, because I have stopped reading law. This is what I do.
It never
When
came to
I-
my notice.
When I come to court, Mr. Patil is there, he will teach me law.
Now, my lord, this extract of this 15.2 also I have annexed here.
Just
My lord, this
into,
deals only with
is-
corporators.
you see, 15.2 is 1/3 out of the total number of seats reserved under section 1 shall be reserved for women belonging to Arunachal Pradesh scheduled women tribes. Now, please tell me one more thing. I'm borrowing this principle from the service law. In a service law, supposing there is a person, there is a post which is reserved for say, scheduled tribes. A general candidate scores less than a scheduled tribe candidate, and therefore a scheduled tribe candidate is transposed to the general category, and therefore he may get an appointment. Now, the issue of women, you see, divorce of that reservation, even if otherwise a women candidate gets elected in the mayor election, she may still become a mayor,
Yes, yes,
correct?
yes. If she is a corporator and then contest in the post of mayor, she can contest. She can be the mayor also. That is, but then without reservation. There is no bar.
So you see 21, now please show from where you are borrowing this provision that it has to be in due process of law that this reservation should be done after following procedure. What is the procedure, which?
Now, that is why, my lord, I have taken your lordship to the provisions of the constitution. My lord, extract is, I have a page 14, annexure 1. 243, I have annexed as annexure 1. So here,
Procedure. What
here,
according to you is the procedure?
yes, 4, the office of chairperson in the municipality shall be reserved for the scheduled castes, scheduled tribes, and women in such manner as the legislature of a state may, by law, provide. By law, provide. Now, my lord, that apart, my lord, the Municipal Act of 2019, 53 proviso provides that provided that the office of the mayor shall be reserved for the Arunachal Pradesh scheduled tribes women by rotation or by lots in the manner prescribed, my lord. Now, my lord, this is where I am catching on, my lord. The constitutional provisions also provides.
কি হয়েছে জানেন?
এটা বস্তু যেটা আসলে এই মানে আরে কি ফর্মুলা বেরিয়েছে করবে সেটা বুঝতে
বুঝতে পেরেছো কি হয়েছে? Reserved for women under section 53(1), read with section 7(2) of the APMC Amendment Act.
it's only women can become a okay that so that
That apart,
Just a moment, just a moment.
Copy dia. Mahu.
so in terms of that they do the lots and after doing the lot for this particular election so it became this by drawing the lot this particular election the post is to go to women. That is that.
Yes, Mr.
That-
Kapil,
that-
is any law prescribed?
Lordship,
Procedure prescribed?
this prescribed Lordship manner, I'll come with the instruction Lordship on this particular point
Ma-
Lordship.
Malad, another point is, Malad, the circular by which the date of draw was fixed, Malad, at page 18, Malad, annexure 4, Malad. Annexure 4, Malad. Annexure 4, Malad.
Page
18, Malad.
18.
May I read, Malad?
Yes.
Whereas, by letter number such and such, from the Directorate of Urban Local Bodies, such and such, it is being informed that the State Election Commission is contemplating to hold the general election to the Itanagar Municipal Corporation in the month of December 25. In these connections, this office is being requested to reserve seats for women and issue notification as per the provisions of the relevant act and rules. Now, therefore, in accordance with section 15.2, Malad, of the Arunachal Pradesh Municipal Corporation, 1/3 out of the total number of seats of councillors oblique corporators shall be reserved for women belonging to the Arunachal Pradesh Scheduled Tribe. The reservation will be determined by drawing of lots at Pare Hall, such and such, at 11 hours on 28 October. Malad. In these connections, the Honorable MLA such and such, Malad. Now, the purview of the circular is restricted only to 15.2. 15.2, I have annexed this 15th provision of 15.2 at annexure 5 also. Malad, 15.2 talks only about the reservation of the councillors, not the mayor. So,
No, it is mayor.
no, Malad, it is councillors.
No.
Now, therefore, Malad, let us see the second paragraph, read, Malad, second paragraph. Your Lordship,
It is.
may I just read again, Malad, this section 15. Malad. 1/2 out of the total number of seats reserved under the subsection 1 shall be reserved for women belonging to the Arunachal Pradesh Scheduled Women Tribes. Malad, there is some typographical error, Malad. Seats shall be reserved in the corporation, Malad. So 1/3, that is 33%. That is for the corporation. And now for the mayor, it is provided under section 53, 53.4.
53 proviso contains that. We have already read that.
Yes. Now there is, my response submission is section 15 and section 53 are two different provisions, Malad. So by acting under the section 15.2, the deputy commissioner could not have reserved the post of mayor. And for the purpose in order to enable him to draw the lots under 53.4, the government has to prescribe, but then government has not prescribed. This is totally clear from annexure 3, page 17, my lord.
You mean the manner?
Manner. Nothing has been prescribed. So this is non-prescription of the provisions as provided under section article 243T and also under 53.4. My lord, the deputy commissioner could not have.
Can the constitutional provision be frustrated?
Exactly, this is my question also, my lord, to me. That the constitution provides that the manner has to be prescribed. Yes, there is a provisions for reservation, but then the manner has to be prescribed. And without prescribing the manner, can somebody just
No,
reserve it?
it's not somebody. A deputy commissioner is not somebody, he's the government.
Yes, my lord. He
For the purpose of a district, he is.
no,
the
my lord.
government.
My responsible submission is he is an administrator under the government, but deputy commissioner is not the government. He does not represent the government. He is acting under the government. So his action will not substitute a decision of the state government. State government has to come by the legislature has to pass the manner and prescribe the procedure, Madam. And they are not having any prescription of the manner and procedures. The deputy commissioner could not have ventured into this by exercising the power conferred under 15.2, Madam. 15.2 is confined only to the corporators, and for the purpose of mayor, it is 53.4. And the condition precedent for Article 243T and Section 53(4) has not been fulfilled. And therefore, exercising this power under 15(2) is not legally sustainable, my lord.
When is the elections due?
December, my lord. Then day after tomorrow, I think tomorrow the final notification for the reservation of the district chairperson will be carried out, and thereafter within these 2-3 days, the final notification shall be issued, my lord. And once it is issued, my lord, then the nomination proceeding, everything will begin.
I mean, what do you understand by the manner? Just asking.
Manner means, my lord, how reservation will be carried out, because it is a single post. So it cannot be 1/3. So maybe it has to be on rotation, because if it is 5 years, maybe these 5 years, it will be general. Next 5 years, it will be general. Then third will be definitely for the woman. And that is how the manners are prescribed. But that not having been prescribed,
Yes, day after tomorrow for instructions.
Lordship.
But Mr. T. Patil, learned counsel for the petitioner, as well as Mr. S. Tapir, learned government advocate, a senior government advocate appearing for the respondent numbers
1 and 3, Lordship.
1 and 3. And
2 I have
A and 2, learned counsel appearing on behalf of senior standing counsel for the election commission. It's a state election commission. Next para. Agreed by the reservation of the post of Itanagar Municipal Corporation for the mayor of Itanagar Municipal Corporation for a woman. The present petition has been filed. The present PIL has been filed under Article 226 of the Constitution of India. Full stop. It is projected that, as per the mandate of Section 53, proviso to Section 53(1), reservation of the post of mayor.
and my lord, Article 243T.
Is prescribed. However, it is projected that the manner to be prescribed must be by the legislature, state legislature. Next para. You should notice, just say, the learned counsel for the petitioner has submitted that there is every likelihood that the notifications for the elections would be issued in a couple of days, and therefore he expresses urgency in the matter. Next para, you should notice returnable on 13/11/2025. So extra copies of the petition be served, of this PIL be served on the learned senior government advocate as well as the learned standing counsel for the state election commission in course of the day. Just say issue notice, including notice on the prayer for interim relief. Returnable on so and so. List on 13/11/2025.
Till day after tomorrow, suspend.
Oh no, then we'll have to dismiss it. The reason is come to 53. come to 53 proviso again. Read section 53 proviso. Read that. Had Mr. Tapin given that answer, we would have dismissed it right now.
Actually, copy was just given to me.
That's okay. 53, you are there. Section 53,
Yes.
read one and then proviso. Read it loudly
The
so that
corporation
we
at
can
first
refresh our
meeting,
memory.
thereafter, yes. Shall,
The corporation shall, at its first meeting and thereafter, at the expiration of every 2.5 years, elect one of its councillor to be the chairperson to be known as mayor and another councillor to be the deputy mayor of the corporation. So here we were asking you that about the amendment. In the amendment carried out in 2021, this 2.5 years has been substituted by 5 years.
yes.
Correct. Now proviso, provided that the office of the mayor shall be reserved for the Arunachal Pradesh scheduled tribes women by rotation or by lots in a manner prescribed.
Actually,
So
my
if
lord,
it is by lots, the deputy commissioner has done it. We don't find anything wrong. If he would have done something illegal, the state legislature would have stripped him by now.
my lord,
Correct.
that
This is
day
so
after tomorrow.
politically sensitive that this officer would have been in trouble. He has done the right thing, and therefore, we don't
No, we,
state.
uh,
Had this reply come from Mr. Ravin, would have dismissed it right now. But since he said issue notice, we are issuing notice. Yes,
2 days on.
they're giving you your copy.
Item number 2.
my lord, in this case, the government is yet to file their affidavit. My lord, the precise, in a brief, this thing is, my lord, in the post of Arunachal Pradesh Police
Promotion may come seniority.
Service, my lord,
But there's already an order for promotion in police.
no, that is pending in the, that will be taken up tomorrow.
Okay.
There's an order that there is no bar for holding the DPC, but DPC has not been.
Here another, my lord, is slightly different, my lord. Here what they did is, the rules provides certain sanction post, my lord. So that sanction post is being diluted by these rules, whereby percentage basis of the post of inspector has been prescribed, my lord. So that is not as per the sanction post. So that is the only issue to be decided, whether they could have diluted the sanction post or not. So anyway, my lord, let them file that.
Clarify it better.
How much time?
2 weeks, my lord.
2 weeks. Sir T. Patil, and counsel for the petitioner. And Mr. D. Pangik, and counsel for respondent numbers
5 to 16.
5 to 6,
5 to
16. So we
16
pleaded ours.
are present. So Ms. T. Bangul, and government advocate, appearing for respondent numbers 1 to 4, has prayed for further 2 weeks' time to file affidavit in opposition in the matter. Next, the learned government advocate shall transmit a downloaded copy of this order to the principal secretary within bracket home to bring the order to the notice of the said authority. Next, list after 2 weeks. The affidavit shall be filed at least 1 day prior to the next date of listing.
Yes.
Item number 4.
Obliged, lordship.
Lordship,
Yes.
on earlier occasion, Mr. D. Sora was appointed as an amicus. Your Lordship is
Yes.
not present today.
The records have come.
Not yet, Your Lordship. On the first occasion, only the amicus was
I
appointed.
understand. You list it next week then,
Yes, Your
both sides are represented. Oh, sorry, there's no representation from the Marcus Curie. However, Miss
T. Ginny, Your Lordship.
Learned APP
Yes.
is present. Next, by the records of the tribunal is received. Stop. Next, list the matter on 18/11/2025.
Deeply.
Item number 5.
That is complete. Your Lordship, service upon the respondents are
Just a moment. Just yes. You have got the service report?
We are yet to receive the service report, Your Lordship. We have already sent the notice to the concerned OC, Your Lordship.
To the police.
Yes, Your Lordship.
Which police station?
It's 0, Your Lordship. Lower
0.
Subansiri. Yes, Your Lordship.
Okay.
One is for Namsai, one is for 0, Your Lordship.
Namsai police station.
One is, one of the respondent is from Namsai, Your Lordship.
And one is from 0 police
0,
station.
yes, Your Lordship.
Okay, Mr. D. Kamdut, and counsel for the applicant is present. Is T. Ginny and APP has submitted that pursuant to the order dated 28/8/2025, she has sent the process to the officer in charge of Zero police station to be served on respondent number 2 and to the Namsai police station to be served on respondent number 3. So however she awaits the service report. Next para. The London APP shall send a downloaded copy of this order by email to the by email or through WT message to the what was it called? How do you send the documents to police?
We send through WT messages, Your Lordship.
WT.
Yes, the concerned police station send their
Okay.
people to receive the same.
Gist of the order by WT to the said 2 police stations so that the officer in charge of 0 police station and Namsai police station shall return the service report positively prior to the next date of listing. Today is 12th. List on 26/11/2025.
My lord, there are 2 accused, my lord, who has been convicted by the same judgment, my lord. And the accused number 2, my lord, he has also prepared appeal, my lord. That appeal number is, my lord, appeal number 20 of 2025. For this matter may be taken together, my lord.
Is service complete in the 20?
No, my lord.
Then let it be complete, then we'll tag it. Otherwise, no, both the cases do not proceed. In that also, please ensure that the service report is complete.
My lord.
Then we'll, for the purpose of hearing, we'll tag it together. Otherwise, there is some difficulties. In one case, the service report is not there, that case will not proceed. The other case will by default not proceed. Correct?
Correct.
Okay. Just remind us when the service is complete.
Yes,
Tag it together.
In fact, my lord, the bail application is also pending where.
But we can't help it. That's why we are insisting on the
Ye-
service report.
Yes, my lord.
process be complete?
Obliged matter.
Item number 6.
Good morning, sir.
Yes, water logging. What is your response?
We have communicated to the department, madam. So far, madam, no communication has been received. Otherwise, also, madam, this is for implement of the these respondents.
They are good people. We need good people very badly. We'll ask them to be here.
Madam.
If you have good company, everybody says it's better. One must be with good company.
Yes, madam.
So we'll ask them to be present.
In fact, I have communicated to the not the secretary, to the RO, madam,
Maybe you are not in their good books.
regional officer, madam. I have
Maybe you are not in their good books. They are not responding to you.
communicated.
Because I remember this is last year we had taken it up. I had also the occasion to look into this matter.
Hence, sir,
Photographs of schools and village roads with water logging, potholes all throughout.
sir, on behalf of the petitioners, may I with all humility apprise the court some key aspect of this petition, how it has come up for hearing today.
No, unless the affidavits are filed, will be very difficult to.
Yes, regarding the
PIL.
implement, this IA itself, keeping aside the parent PIL. Sir, this IA first came up for hearing on 18th September this year. The then presiding justice was about to complete the proposed 6 necessary parties. However, it was Learned Counsel, Mr. Kato, on behalf of the union, who submitted that few time may be given to file a summary short affidavit to apprise the court, showcasing as to whether they ought to or ought not to be implemented. Then matter came up for hearing on 28th October
Who are
2025.
the persons you are seeking to implead? Who are the persons you are seeking
Yes.
to implead?
Your Honor, sir, in the IA, paragraph number 11. In the IA, paragraph number 11 lists out all the 6 necessary parties whom we inadvertently omitted in the PI parent petition. And after due diligence and research, we have come up that they are the appropriate party.
Okay, now please show us that the road in respect of which this PIL is filed. This has been assigned to the Border Road Organization or project Brahmak.
Yes, sir. The stretch of national highway which is concerned in the petition is partly maintained by a border road organization and partly by NHIDCL. There are 2 gates, which is the opening and the closing of the road, and which we have attached in the additional affidavit also. Additional affidavit filed under the IA because my learned brother was not filing any response on behalf of the proposed parties. Hence, I have taken the initiative to so-cause the court as to why they ought to be implemented. In the additional affidavit here, sir, in the additional affidavit, the last 2 annexures, which shows the photo. One is the welcome to Border Road Organization project signboard, after which the gate, the road commences and ends in the NHIDCL gate. So I believe the petitioners have made out a prima facie.
Which page? Which page?
35 and 36, sir. Half portion of the road falls after Bro.
Mr. Kato, then we implead them.
Yes.
Yes, your name?
Marge Lombi.
And Mr. M. Dombi, and counsel for the applicant.
Sir, there is one more prayer for even deleting. These are 2-in-1 petition. And they are to substitute the respondent number 5. Respondent number 5 is Chief Engineer Highway Zone PWD. no objection was noted in the last hearing by the other state parties. They have admitted that they are not the party. Respondent number 5. In the IA, page number 10, we have stated out in the, sorry, paragraph number 10 of the IA. Respondent number 5 is to be deleted.
Counsel for the applicant, Mr. M. Katul, and DSGA appearing for the Union of Indian Authorities thereunder, and Mr.
Your Lordship, on behalf of Mr. G. Tarak, standing counsel for the RWD, respondent number 6 and 7.
Okay, Miss,
B. Mema.
give it, I may make a spelling mistake. Counsel for the counsel appearing on behalf of Mr. D. Kamdu.
G.
G.
Tarak.
Tarak. Okay, then it's standing counsel for the RWD, representing respondent number 6 and 7. And you are for 5.
Madam, I am for 1, 2, 4, and 8 and 9.
1, 2, 4, 8, and 9. Mr.
1, 2, 3, 4, and 8.
1, 2, 3, 4, 8, and 9. Then you are also for 5. Chief Engineer.
No, Madam, that has been, I think, as
Ring 2 Saikia, sir. Sir Saikia.
but the last time it was. They are not a necessary party, like National Hydro.
No, that's okay, but somebody is not representing.
Represented by Ring 2 Saikia.
Okay. 1, 2, 3, 4, 5 is
3, 4, 8, and 9.
1, 2, 3, 4, 8, and 9. Mr. Harish Nawab, that's an additional advocate general. None appears on call for respondent number 5. Next para. By filing this interrogatory application, the applicants are seeking to delete the respondent number 5 from the area of parties in the connected PIL, as well as to implead the authorities were more fully described in paragraph 11A to 11F of this interrogatory application as respondent numbers 10 to 15. Next para. The learned DSJ has submitted that he requires some more time for instructions on the pair for impleading. Next para. Having noted from the contents of the additional affidavit and annexes thereto, that a stretch of this, the concerned national highway is maintained by the Border Roads Organization and the NHIDCL, the prayer made in this interlocutory application stands allowed. Next para, resultantly, the name of respondent number 5 is struck off from the area of parties in the connected PIL, and the authorities whose particulars are disclosed in paragraph 11A to 11F of this interlocutory application are implemented as respondent numbers 10 to 15 respectively. I said that respondent number 5 deleted without altering the seriatim of the parties. Next para. The petitioners, this application stands disposed of. Then in the main PIL you say, in view of order, so in view of the order passed today in the connected IA Civil 203 AP of 2025, for which name of respondent number 5 has been deleted, and the names of parties whose particulars are disclosed in paragraph 11A to 11F of the said interrogatory application are allowed to be implemented as respondent numbers 10 to 15, comma, the learned counsel, the petitioners shall file an amended PIL within a week.
Yes, most humbly, sir, one more permission may be granted with all humility I'm requesting. Since the implement has taken effect now, there may be necessary to change, few words where I stated respondent number 5. So by carrying out nominal changes, I will serve the extra requisite copies to all the parties again.
Have you made that prayer here?
On
Constitutional
fairly submitting, no, your, sir, no such request was made in this petition, in this IA. In written, no submission has been made.
No, you see, under the principles of order 1 Rule 10, once the plaint is amended,
Yes.
you can always amend it. But
Yes.
since you have not given the description of the amendment, we cannot give a blanket permission to make an amendment. You'll have to file an IA, bring on record what do you want to implement.
Sure, I will carry out that, sir.
Next, on the prayer made by learned counsel for the applicant, petitioner, is granted liberty to file an appropriate application for amendment of the for consequential amendment of the PIL. That we have said copies to be filed within a week. You delete that, and you say the order for filing of the amended PIL shall be passed as and when orders are passed in the application proposed by the learned counsel for the petitioner for amendment of the PIL.
Thank you so much, sir.
Item number 7.
Your Lordship, Your Lordships, I deeply apologize, Your Lordship. Lordship, this matter is being taken up by my brother, learned additional PP Jeet Ado, Your Lordship. He's not present in the court today, Your Lordship, due to some health issue. If I may
Health
pray,
issues.
yes, Your Lordship. If I may pray, this matter be taken next week, Your Lordship,
Next Tuesday?
next Tuesday.
Okay. Both has a represented. Miss T. Ginny, learned APP has submitted that this matter is allotted to Mr. G. Tagore, learned APP, who is indisposed today. Next para, accordingly matters stands adjourned today. List again on 18/11/2025.
I'm deeply apologize.
Item number 11.
Lord, I am ready for the respondents. Appellant side.
My lord, may I pray that may some time may be given. Maybe if it is possible, if Tiwari sir is ready, then it can be fixed on 14.
I am ready even today.
But I'm not ready today. So it can be fixed on Friday.
Friday will be a bit difficult.
How could it be on Friday?
14th.
Look up,
If not, then
you are doing or somebody else?
I will be doing if on Friday then.
No, Friday will be difficult
Friday
because
to
we have to wind up.
it up.
We both will have to wind up, pass all orders, release every file we have. So
Then,
hitting on that day would not be possible. You do it on Thursday, it's possible, we'll take it up.
Thursday.
Thursday, my lord, then I'll be stranded here for the whole week because Thursday I thought sitting in Guwahati I will do VC with Mr. Das because otherwise today is Tuesday, tomorrow day after, my lord. Not
Good,
Thursday.
always good to be in the court.
It's a, my lord, it's a wonderful case to be argued. Very interesting point of law is involved. But the thing is, my lord, till
Then it
Thursday
goes to
I'll be
next week.
caught.
Then it goes to next week.
Then next week, my lord,
Next week.
Justice Kardak is till first week of December.
I can be here. I can be here, my lord, on
So then it should be posted in second week of December.
27th. I have got the matter fixed here already.
No, hear him, what he's trying to say.
Justice Kardak is till first week of December. So So
Justice
that's
Kadagete has got to do?
Justice Kardak will not be appearing this matter.
He has recused himself.
He was the when the
No, but 26th of November, 27th of November, Justice
He is
Ete
there.
is
it is there.
It can be 10 after 10.
Then it goes
After
to December in
It's
that
after
case.
10, from
15th of December, my lord, otherwise.
15 of December. 15th of December, then,
Okay. Otherwise, both sides are represented. Both sides, Monday. PK Tiwari, Learned Senior Counsel for the,
Rolled over.
your call,
My lord, I'm for appealing for NHPC, the
for
respondents,
NHPC is present.
3 and 4. Huh?
On the prayer made by Learned Counsel for the petitioner, the matter stands adjourned today.
My lord, it is his prayer.
Petitioner,
Yes.
you become too engrossed.
I'm sorry.
50,
I wish I could have argued this case today itself. Very interesting question of law is involved. Lordship would have enjoyed it.
Obliged.
Here is the case, my lord, where the Supreme Court judgment in the Indore Development Authority case will be looked into and interpreted. Interpreted by your lordship, because here is an area where the principle is there in the Indore Development Authority, but the principle has to be applied in the ground. The proviso to section 24 subsection 2 of 2013 Act.
argument.
Obliged.
yes.
May I, Your Lordship? Your Lordship, I beg to mention item number 26 and 27, Your Lordship. Since these cases have been handled by Learned AG, Lordship, and he has prayed for fixing a date on 17th of this month, Your Lordship.
17th.
17th, Your Lordship.
Okay. Who's for the other side? You are taking consent?
Yes, Your Lordship.
Okay. Both sides are
Well,
represented.
Mr. Doloy also had,
Pardon me?
Mr. Doloy is appearing for the,
For the Union of India.
yes,
Okay.
he also is mentioned for 70.
Both sides are represented. On the prayer made by Mr. Estafin, Learned Senior Government Advocate, the matter stands adjourned today, list on 17/11/2025.
Your Lordship, Vairi Ram, Your Lordship. Vairi Ram.
Oh, sorry, Vairi Ram. I'm sorry.
It's okay, Your Lordship.
Right, sorry.
Obliged, Your Lordship.
May I, Your Lordship? Your Lordship, I beg to mention item number 10 and 11 with the consent of the other parties, Your Lordship. This matter may be posted for 19th of this month, Your Lordship.
10 and 11.
Yes, Your Lordship.
Okay, both sides are represented. The prayer made by Learned Counsel for the
Petitioner in item number 11.
petitioner in WBC 481 of 15.
Yes, Your Lordship. And in
Okay,
item
list
number
on
10,
so and so.
in item number 10, I am for the respondent number 3.
It's okay. One.
Highly obliged.
May I, Your Lordship? Yes. Your Lordship, I beg to mention for item number 6.
6.
Yeah, yes, Your Honor. Yes, Your Lordship, I'm for the petitioner in this case. And Your Lordship, the main counsel for this case is out of station due to some medical problem. So this matter may be listed after 2 weeks.
Okay. Both sides are represented on the prayer made by Learned Counsel for the petitioner. List after 2 weeks.
May I please, my lord? My lord, I beg to mention item number 7, my lord. My lord, here in this, we will be filing rejoinder, so we need some time to file. We have received counter affidavit.
Rejoinder affidavit.
Yes, Your Honor.
Okay, both sides are represented on the prayer made by Learned Counsel for the petitioner. List after 2 weeks, so it was to enable the petitioner to file a rejoinder affidavit. In the meantime.
My lord, I beg to mention item number 12. I'm appearing on behalf of Mr. Estae. I may be allowed some more time to file an affidavit.
This is 22 matter.
Yes, Your Lordship.
It's a matter of 2022. So we have more than 3 years. Why should we give you time?
Your Lordship, senior is out of station. I'm appearing of his instruction.
For whom you are seeking time at respond number?
4, respondent number 4. Our matter may be fixed after 4 weeks.
No. 2022 matter, no 4 weeks. We give you last chance, otherwise it will be closed. We'll proceed without your affidavit. We'll make it very clear. Both sides are represented. On the prayer made by Mr. Style and the counsel for respond number 4, one last opportunity of 2 weeks is granted to the said respondent to file affidavit in opposition in the matter, failing which the matter would be heard on the basis of materials available on record. Without granting any further adjournment to respond number 4 for any reason whatsoever. Please don't give a date after 2 weeks.
27/11.
Much obliged.
Delivery of order, item number 1.
It's a typing error here. Should be capital. No, do it later. You can do it later. Let's send it to the PS. The writ petition is dismissed at the motion stage without issuance of notice on the respondents. There's a small correction in page number page number 3. Within half an hour it will be uploaded. There's some corrections to be made.
Item number 2.
Correction, huh?
May I please, Your Lordship?
Yes.
My Lord, matter is regarding a tourist lodge which was in a dilapidated condition. There was a proposal from my side which was submitted at page 21. This is 23/5/2002. My Lord may see. Proposal was to renovate, own, operate, and transfer route basis.
No, this
My Lord,
I fail to notice any order requiring this to be on the to be let out on the operate and transfer basis.
No, no.
Notification, no.
No. This is,
Proposal.
yes, there was a proposal which they had accepted. And thereafter, I was made to deposit the security deposit, which was of 5 lakhs. And I had also made some investments because the tourist lodge was in a very dilapidated condition. So that is why this whole thing was done. There was a...
What happened to Article 300, 300?
Lordship?
What would happen to Article, I think 299? What would happen to that? No, at best we'll issue notice on the prayer for your refund, nothing more.
Lordship. We came to know only through the additional affidavit that there was some, the cancellation was done finally. That was January 2024. So this Honorable Court was of the opinion that matter itself had become infructuous. So that is why it was closed. Now, since January 2024, they have not actually floated any NIT, nothing. They have not even refunded till now.
We'll issue the direction for refund.
Lordship may issue notice because I'll have to bring on record the expenses that I have incurred also. At the moment, Lordship, I have not.
That would be a civil dispute then.
No, Lordship, if they admit it, then that this honorable court can pass orders, Lordship. If they disagree with that, then that's a different thing. Lordship may issue notice.
Where is that order dated 30/8/2022? Where is that?
That is, Lordship, at page 28.
And this,
Page 28. This was in supersession of the order dated 14 July 22.
just a moment.
28, Lordship.
Okay, and where is the order dated 25 January 2024?
That is, Lordship, at page 32. Annexure 9.
Then even your notice for the purpose of the monetary claim,
Yes.
that will also be restricted to advance if any paid. There can't be any other notice for any other expenditure. Come to page 32.
Yes, Lordship. The last
Number two.
paragraph, Your Honor.
No. Serial number 2.
Yes.
The said asset is not yet handed over to either party or it's under possession of the said parties. The said asset is still under the tourism department.
Lordship, it is only for the purpose of physical possession, but
I'm just
but
trying to understand something.
Lordship, because of their position in the matter, I was allowed to renovate.
No, possession is not with you.
Lordship, position is
Better.
physical position actually with no one at the moment because it is left just like that. So I was asked to do it.
Then you see there are
They could not have taken that position if they were, Lordship, not.
then we can't do it. Then we can't do it. How the officers will get position? You will direct the authorities to lodge an FIR. Position was given over to you
Lordship, it was
against the officer who has given you position.
in order to, Lordship, that thing, Lordship, we had, yes.
I'm
I
just testing
had,
this. I'm just testing these theories. My examples are horrible, so please excuse me. You see, you quote to a client a fee of, say, let us say 10,000. The client, what he does is he comes to your home, paints your house. Correct.
Yes.
Now, that painting was never solicited by you. He just came one day and you are in court and he started painting your house, did the entire whitewashing and left. Now, does it absolve you from does it absolve your client from paying your fees? Because the work of painting was done without your consent. You are in court arguing the matter here.
Yes.
Now, supposing this time somebody client.
Lordship, it had reached the level of approval from the government. I already made the security deposit.
299 is hit.
Lordship.
If somebody has done it, you lodge an FIR against that officer who has taken deposit. Article 299 prohibits that.
The deputy commissioner had taken the deposit.
Fine, whosoever high he may be.
Yes. But it was on it was based on the approval by the government, by the department, Lordship.
But 300 is not complied. If he has done it, then you have a free hand. Why settle for 5 lakh rupees? You have a free hand.
My whole argument is, Lordship, that if they had not taken this position, if they're not given the approval, if they're not asked me to deposit the security amount, I would not have met any expenditures, Lordship. But now, like,
We
there,
have a word for it, pro bono. Publico. That's why I give that example of somebody coming and painting your house. My property, how would somebody come and just spend money on it? Sorry, your petition would be dismissed with liberty to you to avail the remedy of getting refund of your deposit of rupees 5 lakh. Where is the deposit made? How do you show that?
that is, Lordship, at page 26.
26.
Starts from page 25. This is the covering letter.
Yes, it's a pledge, Ms. Hete.
Lordship,
You refund that back. This is
Lordship.
only a pledge of fixed deposit.
yes, Lordship, 5 lakhs, because
Within 7 days,
within 7 days, Lordship, within 15 days. Like it,
15 days.
yes.
This was in 2022, Lordship.
Oh, but this is a fixed deposit receipt.
Yes.
Correct.
Lordship may also allow me to approach the civil court so far as the other expenditures are concerned. Because it is.
No, you withdraw it then,
Lordship,
because we won't permit you. You
Lordship.
can withdraw it to avail
I'm-
the remedies.
I'm not talking about the security deposit now, but the expenditures that I had made on their behest,
For
Lordship.
that you withdraw this writ petition, we are not passing any order to allow you a liberty to approach court. We just record your prayer.
In that case, Lordship, this matter may be taken up tomorrow. I'll confer with my client.
Okay, on the, both sides are represented on the prayer made by legal counsel for the petitioner, list on 12/11/2025.
Oblige.
Item number 3.
My Lordship, may I please to pass over for a timing matter, Lordship. Timing, Lordship.
Item number 4.
Wait, please.
Yes, Mr. Pangi.
My lord, may I kindly have page 99. The petitioner, my lord, is challenging.
Quota
this-
for promotion.
Yes, the private
It's a
response,
notice here.
my lord.
And Mr. Deep Pangi, and counsel for the petitioner. As well as Mr. Estapil and senior government advocate appearing for respondent numbers
1 to 4.
1,
1 to 4.
1 to 4. Next para. The petitioner projects that he is a person with disabilities.
No, my lord, the private respondent is a person with disabilities.
Acha, the private respondent is a person with disabilities. And the respondent authorities on quota for persons with disabilities had promoted the respondent number 5.
Right.
In terms of, no, on the basis of OM dated 31/5/2019.
19.
Accordingly, the order of promotion dated 19/8/2024, signed on 27/8/2024 is assailed by filing this writ petition under Article 226 of the Constitution of India. Next, issue notice returnable in 4 weeks. Extra copies of the writ petition be served on the learned senior government advocate within 2 days.
Right.
Next para, the petitioner shall also take steps within 2 days for service of notice on respondent number 5
Right.
by registered post with AD. Next para, the learned counsel for the petitioner is at liberty to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. next list after 4 weeks.
Pass over matter, item number 3.
Sorry, my lord, I got late.
Yes.
Well, this challenging the impugned technical minutes stroke board proceedings dated 16/10/2025 relating to the NIT issued by Deputy Commissioner is coming district on 24/9/2025 for supply of material under Mandriga 2025-2026 package number 7 Sawa block amounting to 2.5 crore. My lord,
This was a requirement of submitting an NOC.
No, there is no such requirement. I'll demonstrate, my lord. Now, my lord, the second count, which I am challenging is, there are infirmities in the documents of the private respondent number. Private respondent, my lord.
That may be there, but on that account, they can always be terminated whenever this is brought to their notice.
Right, my lord.
At the time of technical evaluation,
Correct, my lord.
the authorities will not know whether my car has registration or not, whether it is valid or not, whether I have a license or not, whether the driver's license is correct or not. So this will be the basis to every tender now has a clause that any wrong statement is there, they would be putting aside the award.
My lord, kindly you have it. One moment indulgence to page number 37.
Where is the comparative statement?
Comparative statement is, my lord, at
Did you raise that objection?
104.
Did you raise that objection of the?
Yes, we have raised the objection, my lord. Representation was filed on 28/10/2025 itself, my lord. Which my lord will find.
2010 is post proceeding.
Yes.
Post proceeding will not be there, but on that day, did you make an objection? No.
That it will be clear from the representation if we read, my lord.
Where is that representation?
105, my lord. I am required to file because there is no condition prescribed in the NIT itself that I should file an affidavit on the condition of NIT. Now, the first question that has fallen from my lord was that whether the private respondent's car was having a valid license or not. That is subject to the disclosure at relevant point of time. But similarly, in my case, my lord, this is not the case. And this was never been a condition or never been a part of the terms of the SBD, my lord.
Mr. Vijay, you have the instructions on this?
My lord, yes, my lord. In fact, my lord, this representation was disposed of. My lord. Page 109, my lord.
No, it's not a question of disposal.
Yes, my lord.
Mr. Tara is making a statement.
Yes.
That the condition of NOC
yes.
was not prescribed in the tender documents.
Yes, my lord. May I please kind to page 109. That would there is an answer, my lord.
109.
Yes, my lord. This is a subsequent development which they have not challenged, my lord. Paragraph 1, my lord.
Yeah, challenge.
Here is the answer, my lord. The board members convened pre-bidding meetings on 3rd October 2025 and 6 October 2025, during which a common checklist applicable
Where is this mandatory requirement? Which clause of the tender?
Clause 11, my lord.
Page?
Page, my lord. 38, my lord.
In our favor.
38.
11 and 13 is important.
11.
Any agency involved engaged in the litigation, arbitration with the department at present or blacklisted with any government autonomous organizations are discouraged and disqualified from participating in this tender. In the event of such disclosure at latter, my lord will mark this. In the event of such disclosure at latter stage, even after acceptance stroke award of work shall automatically lead to termination of contract, including forfeiture of earnest money, including security deposit, my lord. Here, my lord, they have simply said that we have not filed an affidavit, but your condition does not stipulate that we should file in the form of affidavit, my lord. One, my lord, kindly see para 13, say, serial number 13, my lord. What are the requirements, my lord? Trading license with up-to-date validity, Aadhaar card, permanent residential certificate, contractor registration certificate with validity, up-to-date validity, self-declaration of contractors on forms, letterhead, scheduled tribe certificate, original certificate, demand draft, GSTN, TAN, updated return and validity, solvency from any nationalized bank, not less than 50%. My lord, here in page number 113, my lord, I will demonstrate. This private respondent has submitted an undated bank guarantee, my lord.
No, those are, bank guarantee is there. If it is undated also, doesn't matter.
Fine,
Because
my
the
lord.
bank guarantee will always carry a number and a date.
It is not there.
It has to be there.
It is not there.
100?
114, 111, my lord.
This is solvency certificate.
My lord, no date, nothing.
It's okay. So solvency certificate.
Solvency.
And for this, we have we went ahead because of the affidavit file, affidavit, my lord. The declaration made by.
Affidavit is where? Where is that affidavit clause?
It is not there. It is not there.
No. Let him.
For this, my lord, solvency certificate, my lord. Solvency certificate, my lord.
No. The affidavit for which you have rejected his tender.
Yes, my lord.
Where is that clause? You said it was.
There was a pre-bid meeting, my lord.
Where is that?
Page 109, my lord. Paragraph 1, my lord. Because of that. This is the answer. Paragraph 1 is the answer. The board members convened pre-bid meeting on 3rd October 2025 and 6th October 2025, during which a common checklist applicable to all 8 bidders of the district was framed and duly approved by the board, my lord. So, my lord, there was some deviation probably.
No, just a moment. You are not being able to follow.
No, yes.
Say page 109 is a pre-bid.
Yes, sir.
No, it is not.
No,
pre-bid.
it's not. It is not a pre-bid. It is a disposal of their complaint, my lord.
We are not on that.
Yes, my lord.
Specific question,
Yes,
need a
ma'am.
specific answer.
Yes, ma'am.
You rejected it on the ground of affidavit.
Yes, ma'am.
Where is the requirement in the bid document? Or where is the requirement which has been expressly told to them in the pre-bid meeting?
This clause 11, my lord.
It is not there.
It's not there, we state.
My lord, I have one objection, my lord, on the point of law, my lord, whether this writ petition is maintainable or not, my lord.
Definitely.
No, my lord, this sole proprietorship firm, whether can file writ petition, my lord. Order 30, Rule 10, my lord. CPC, my lord. Order 30, Rule 10, my lord.
You see, a person
My lord.
is also, or is always, so far as partnership, this is concerned.
This is sole proprietorship firm, my lord.
He is the owner.
Yes, my lord. Sole proprietorship firm cannot sue, my lord. He can be sued, my lord.
Where is that? Civil procedure code is not there. Civil procedure code.
There is a fine judgment by late Justice Nishiteru Chaudhary, my lord, on order 30, my lord, Rule 10.
What is it, judgment?
I have not brought, my lord, but I can provide, my lord, tomorrow, my lord.
My lord, the only thing is that I have filed in my name, not in the proprietorship form. He is correct, the question which he has raised, but there is a rider as well, my lord. A sole proprietor cannot sue in the farm's name because the business lacks a separate legal identity from the owner. The owner must sue in their own name, although the lawsuit can be described as being on behalf of the business. So is contention, my lord, I was aware this question would fall on me.
No, but then the nomenclature is wrong if you are aware of it.
Affidavit, my lord, we have.
But this is, you see, this is a defect which will not matter. We'll always permit Mr. Tara to file a amended cost title.
Yes.
End of the matter.
Yes.
It'll come to tomorrow. No, for this, it's not, this case will not go for non-gender because he's representing.
Yes,
Mr.
yes.
Tara will just have the trouble to.
My lord, there's a subsequent development. which
My
has
lord,
not-
secondly, before my brother comes up with the point, my lord, secondly, kindly come to page 104.
Yes,
Observation column, my lord, will come.
yes.
As per the decision of the Technical Bid Evaluation Board recorded in its proceeding dated 6 October 2025, the requirement for physical submission of the financial bid as per NIT has been relaxed. My lord, rule of changing games. This is not permissible, my lord. So, prima facie, this has resulted into the arbitrariness. And therefore, my lord, according to them, according to their own SBD terms and conditions, they are supposed to recommend 3 firms to the directorate, and then director level, when they do the re-evaluations, then only the deputy director will issue the letter, LOI, letter of intent and the work order. So, well, there was one case which I have done before Lordship also. I forgot to bring that. Otherwise, I have this Justice Michael Jothan Hummer's judgment. And then, my lord, let us, in the service law, my lord, when the interview process has been set into motion, you cannot change the.
This doesn't help you because you're technically out.
Yes.
After that, whether the financial is sent by email or it is sent by physical, doesn't bother you.
Well, this
It will not be a ground.
my lord, just I am trying to point out that how
No,
the Malafai,
My lord, may come to please 109,
If it's an
102.
online submission,
correct, sir.
it had already been uploaded first.
Yes.
It's not your case that after the technical evaluation you are out. After that, the fresh submission of the financial bid is required. No, not that.
That's fine, my lord. At least I have brought on record with clean hands, my lord.
No, it's okay.
Whether it goes against.
When did we bring it? Take it out tomorrow. For Mr. T.T. Taran and counsel for the petitioner, explain Mr. V. Pichar.
Standing council RD. Yes. Standing council RD, my lord.
RDB.
Yes, RD.
This is a preliminary objection. The order 30/10 of the CPC to project that the proprietorship firm cannot maintain a rate petition.
Sole proprietorship.
Next para. Sole proprietor cannot maintain a rate petition.
No, my lord.
Where is that? Show us the
No,
judgment.
cannot sue. Cannot sue. It can be sued, my lord. It is in the order 10, my lord. Rule 10, my lord. It can be sued, but it cannot sue in the name of firm, my lord. Sole proprietorship.
That's why we are saying.
Yes, my lord. Yes, my lord. I can.
No, did we say anything wrong in the order?
No. Proprietorship firm, my lord has.
My lord, in my
So the owner will always be able to sue.
My
my lord, in my course title, kindly see page
No,
5.
represented by would not do. The petitioner would be still your firm.
I seek the liberty to amend this.
We are giving it that when without your asking. Objection, first of all.
Page number 5 only, my lord.
As it is noted that the firm of the petitioner, the petitioner firm is represented by the sole proprietor, comma, and the justice would be met to permit the petitioner to amend the cost title of this writ petition in a manner appropriate to order 30 rule 10 of the CPC. Next, the Learned Counsel for the petitioner 6. How much time?
Tomorrow only, my lord. So I'll file it tomorrow.
Uh,
Today I'm correcting and
should be
tomorrow.
done in course by the next working date. Post of the same shall be done in the presence of the it will be Registrar Judicial. This correction will be in presence of whom?
Deputy Registrar Judicial.
Deputy Registrar Judicial.
You correct it
And thereafter the matter will be listed again in the motion column.
tomorrow.
Whatever once you do it, then it will come.
Yes. Yes.
Tomorrow?
Tomorrow.
We are not saying that. He'll have to do it by tomorrow, then only.
Yes. How long is it?
Item number 5.
Lordships, I appear for the petitioner.
So the leading counsel is appearing through OBC.
Lordships, I appear for the petitioners. I'm audible, Lordship. Am I audible?
Yes, well, issue the notice. You produce the copy of service of that.
Yes.
Notices to them. Your name?
Arun Jain.
Mr. Agent and counsel for the petitioner. Next, it is projected in this writ petition that the recovery notices which page are those recovery notices?
Lordship's recovery letter is at page 55 and 56.
We are not hearing you properly.
Page 55 and 56, Lordships.
Yes, which page is being referred to? We are unable to hear you.
Lordships, page 55. No.
55.
And 56, Lordships.
But then if you have collected these notices, how can you now challenge it by saying that it's not been served? You collected it from the office. Then how your writ petition would be maintainable?
Lordship, I recently received a phone call and then I collected it. It's very recently that I collected all this. These are never served on to me. In fact, even the issued order has been passed expired.
Did you make an application for a copy or you just?
Yes,
It's not there.
Yes, Lordships, that is at page addition 6, page 57.
57.
Lordships, yes, we requested to provide proof of service and their reply is annexure A.
Replied page number?
8, Lordship, page 62. So in 2022, I attended a personal hearing before the respondent of the case. Then there was a change in the officer And after that, they claimed that they had given me another hearing in 23, which I never received. So after 22, I have never received any correspondence from them. And even in their letter, they are not disputing that part. They are now referring to what happened in 2022. Even the order, impute order was not sent to me, Lordships. So this has been passed ex parte. So on 16th of February, I attended Lordships. If page 62 Lordships have. And Lordship, now I am stuck because I cannot even file an appeal against this order. Just I need to file it.
Next para. It is projected that the copy of original order in original dated
Dated 23rd of June 2023.
23/6/2023 and subsequent notices of recovery dated 16/4/2024 were not served. It's 16/1/2024 and 16/4/2024 were not served on the petitioner. Whereby the right of the petitioner to file an appeal against the order in original is validated, the present writ petition has been filed under Article 226 of the Constitution of India. First off, in this regard, the learned counsel for the next para, in this regard, the learned counsel for the petitioner has referred to the reply dated 8/9/2025 issued by the superintendent within bracket TAR close, wherein it has been mentioned that the copy of order in original was sent to the address of the petitioner and the same was not returned. And therefore, a presumption appears to have been drawn that the order in original was delivered to the petitioner. Next para. Issue notice returnable on how much time?
3 weeks, madam.
3 weeks. Give a date after 3 weeks. Returnable on so and so. Requested extra copies of the writ petition, as well as a soft copy of the writ petition be served on the learned Mr. M. Kato, learned DSGI, who in course of the day who accepts notice on behalf of the respondents.
Madam.
Stop till the next date of listing, the recovery pursuant to the order in original dated 23/6/2023 shall not be enforced. Next, the petitioner shall produce a certified copy of the order before the Before whom? Before the Joint
Joint
Commissioner,
Commissioner.
CGST and CX, Itanagar, within bracket respond number 3. To make the order effective on the said authority. Next para, list on
Second 12, 212.
2/12/2025.
Lord. Lordships, may just one more point I will point out. Lordship, this order is also passed ex parte. Lordships may just record that challenge also.
Pardon me?
This order has been passed ex parte. So I am challenging for that and also that there is violation of natural justice.
No, for that you'll have to file it before the appellate authority.
Lordship, ultimately that it is the conclusion of this matter.
No, we won't accept the challenge because then it would lead to dismissal because that part of the challenge cannot be accepted here. You just recorded your statement that your right to file an appeal has been violated. Only that much.
Lordship,
Your
if for the limitation doesn't come into picture, because the practice that this order is 23 and the time period of filing the appeal is over. As of today,
No, but then that if you are making that prayer, then that challenge would be refused.
if lordships can condone that delay part, then I am ready to file appeal also. I have no difficulty because this order was never communicated.
So that we have made an observation. We'll pass the final order, not an interim. No interim
No.
observations for that.
Lord. Obliged. Obliged.
Item number 8.
I'll take it myself. This file. Keep it here. I'll take it myself.
Lordship, this is regarding compensation. Lordship, I have been paid half of this compensation, Lordship. There remain.
Okay. Yes.
Lordship, I'm sorry, but till now we have not filed affidavit in this matter.
So, Lordship, last time there is instruction that in case of the failure of the filing affidavit, that final consideration of the submission will be considered, Lordship. Taken. And this is crystal clear, clear prima facie, Lordship.
Can you speak to your officer and come back? Because otherwise now you say that if the interest is payable, it would be recovered by your officer, from your officer. At 2 o'clock, tell us.
Lordship, this week?
No, not this week. Once there is a judicial order, we'll be hearing the matter. We'll take up the hearing at 2 o'clock. Ask the officer if they can give you instructions in course of the day. By 2 o'clock, that is okay. Otherwise, interest payable by the state would be recovered from your officers.
Lordship, most of the time in district the deputy commissioners, they are not reachable, Lordship. That's
can't help it
very
then.
difficult.
Can't help it.
Not reachable, maybe 1 time, 2 time. There has been many time, and this same submission is.
Lordship, let it be on Thursday. Then, if there is still, then if there is no word, then
We have a judicial order, it will be taken up for hearing.
Lordship, I try to reach there. Obliged.
You can tell them this is, I believe we are online. There is a live transmission of the proceedings going on. We ask the officers to look at the proceedings. They will understand what is the intention of the court. If they don't file affidavits, they are levied with the interest. They will be recovered from them. Yes, item 9.
Government is yet to file affidavit, but Lordship, I have to file some additional documents also.
You want to
That the
file
government-
additional documents?
Yes. Connected with records. I may be allowed to file.
But you've taken time earlier also.
Yes, it was.
Okay, on the prayer made by Mr. T. Tapak, learned counsel for the petitioner. How much time?
After 2 weeks.
2 weeks' time is, further time is granted to file additional affidavit. In terms of order dated 16/6/2025. Next para. As the petitioner is proposing to file an additional affidavit, comma, the filing of the affidavit in opposition by the respondents would not be necessary at this stage. First of all, further orders to file affidavit in opposition shall be filed as and when the additional affidavit is brought on record.
Yes. Apply.
Just after
After
2
2
weeks.
weeks. 2 weeks.
Item number 13.
My please, my lord.
Yes.
My lord, is a case LPC cancellation. The LPC was issued 3 months before the site verification report provided by the concerned circle officer. Page number 13 is the LPC. LPC was issued on 1st February 2023. And
Yes, what has happened?
3 months prior to the submission of site verification report, this LPC was issued. On this LPC, land was belonged to the petitioner, and respondent was allowed to temporarily stay there. But without informing, without permission from the landlord, the private respondent obtained this LPC. And it was
LPC is under which provision?
Land Settlement, the Land Records and Settlement Act. There is a provision.
Give that act, land settlement.
And in that, for cancellation, I have submit application before the deputy commissioner for cancelling that LPC. And it was the land deputy commissioner reluctant to respond my application. For that, I filed this representation. And in the affidavit in opposition, the deputy commissioner admitting they are not responding my application, and their affidavit also said now they are ready to respond my application. So it is better either to cancel the LPC or to remand to the land deputy commissioner to decide this LPC.
Which provision of this is LPC?
LPC is
LPC provision. Yeah.
2008. Lordship, as my learned friend has already prayed for, Lordship, this matter can be remanded back to the Deputy Commissioner, Lordship, so that he.
No, question of remand is not there because we are not adjudicating that. His main grievance is that they are not taking it up.
No, Lordship.
His first plea is for the direction to the authorities to dispose of the LPC cancellation application. But we are just wanting to know under which provision is that LPC. You find it out, we'll take it up at 2. It must be the law before we pass an order.
Lordship, if Lordship is having the land settlement and records rule, Lordship, then Lordship, it is under Rule 143.
Rule 143.
2012, Lordship. Land settlement records rule 2012, Lordship.
Yes. 143.
LPC is issued, Lordship. So Lordship, in the affidavit, we have said that we are ready to, Lordship, dispose of their applications.
Pardon me?
Their application, Lordship, which is pending in the office of the Deputy Commissioner, Lordship.
But you see, this 143 is issue of certificate. This is not for cancellation. What is
Not
the-
for cancellation. This is of
Then-
course issue of certificate.
Then
Cancellation, Lordship.
where is a copy of the act? Land Settlement and Record Act.
Rule, Lordship, not act.
There's no act.
Act is also there, Lordship.
Act
So we-
2000.
The act would have it, I
Act
think.
Land Settlement and Records Act 2000, Lordship.
2000.
Sure.
Copy cancellation. LPC also cancel.
Application. The 19 development application.
Cancel 899.
Cancellation के लिए हमने application भरा है, cancellation. Lordship, this matter may be listed again tomorrow, so that we'll bring with the entire rules and provision. Because today I have not that rules and act. Yes.
No, this is again rules, not rules. We need Act 2000.
Act 2000. Land Settlement Act
It's
2000.
it's a book like that.
2000 would
It's a
be
book like that.
Volume 7,
7 या 8 में होगा.
7 or 8. It would be. Lordship, I'm sorry, but if this can be taken up tomorrow. Even
Just
we'll come-
just a moment.
Man करेगा, भाई का।
Yes, this is what we wanted. What was that provision? 100 and land position certificate?
Lordship,
Rules?
it is rules 143, rule 143, Lordship. Land settlement and records rule 2012.
Yes, 143, yes. Yes, this is the issue. We'll tell you why.
Lordship, this petitioner is here before this court.
Pardon me?
Lordship, praying for cancelling of this private respondents LPC.
We'll tell you
Lordship,
why.
and then this private respondent is not here till now, Lordship.
That's okay.
In that case,
We
Lordship,
are not dependent on that.
at the most, Lordship,
We'll tell you why.
Lordship,
Both of you are praying for an adjournment. We are not granting it. There's some reason for that.
of Lordship.
With respondent, they have filed their affidavit.
79. Then this.
Oh, he is here already, Lordship, but it's not present today.
An LPC,
I'm like that old tube light. It takes some time to ignite. Yes. You see, in the act,
Lordship,
the court, this revenue officer is called a court,
Lordship.
correct? And against that, you will find a provision for appeal. So this is not, this is unlike say, section 6 of the, I think it's 6, give me that, General Clauses Act. It is not like section 6 of the General Clauses Act, which says that a authority who can pass an order can also cancel it.
Yes.
So it is excluded by the appeal clause. So a person under the scheme of this act, that is why the authorities, you see the rules, there is no provision for how the officer will adjudicate the cancellation prayer. It is not there. Because in the act, you will find a provision for appeal. So if it is a revenue court granting an LPC, cancellation must be done by an appellate authority. There can be no other interpretation.
83 cancellations.
Yes,
The appeal, is the provision of appeal.
Whatever is happening in the state is not in accordance with law.
And let's put this. तो मेरा एप्लीकेशन को बोर्ड ऑफ पास नहीं किया है मेरा एप्लीकेशन को पास करने से पहले उसको जाता है
It's just been passed by.
पीसी प्रॉब्लम दे सकता है
It's passed.
पीसी डीलर सो उसका एगेंस्ट में जाने से
Yes, this is,
By
give this,
पीसी
DC.
डीलर्स
give this one.
this.
This is-
लेकिन ऐसे सारे जो
DC करता है.
लॉक पॉइंट कौन करना है या ऐसा नहीं बात ये पकड़
Lordship.
Look at this 21.
जनरल प्रोजेक्ट
By virtue of the act, the power of appeal being granted, it will take away the power conferred under section 21 to rescind the order.
Lordship.
Therefore, even by consent, we will not be able to pass an order. Therefore, we are posing a question and then adjourning it. Both of you do some research work and then come back. Give those books. It will be required for my order.
Yes, Lordship.
My lord, this is the actual position of the law in our state. Usually we do it, but as per law,
We understand, but this is a question
rightly
which was
my
there
lord
in my
has
mind,
find out.
suddenly when this matter came.
Yes,
Lordship, LPC usually cancellation is also done by the deputy commissioner.
Where is the rule? It's not
The
there.
practice is here.
Practice is there, but every practice is not healthy.
Yes.
Even the secretary usually direct the deputy commissioner.
That's why we are posing a question. We'll give a notice to the state that the Advocate General come and apprise us. We'll be issuing, it's a question of law.
Yes.
We are not passing any order right now. We are giving the state an opportunity to tell us. Mr. T.
Torum.
Torum, Learned Counsel for the petitioner, as well as Ms. G. Atel, Learned Additional Senior Government Advocate for the state,
For respondent on one only. Lordship.
for state respondent number 1. There's no representation from respondent number 2. Next paragraph. In brief, the case of the petitioner is that an LPC was issued by the authority in favor of the respondent number 2, which the petitioner asserts to be illegal. Full stop. Although the petitioner has applied for cancellation of the LPC by submitting an application on 28/9/2023, but the grievance of the petitioner is that the said application has not been disposed of. Next paragraph. With the said factual background, the it appears to the court that as per Rule 143 of the Arunachal Pradesh Land Settlement and Records Rules, 2012, provision is prescribed for issuance of a certificate in respect of each holding to a landowner, certifying the nature of his title, the revenue payable, and the area, giving such other particulars as he may consider necessary. Full stop. The Learned Counsel for the petitioner, as well as the Learned Additional Senior Government Advocate, have not been able to show any provision under the said 2012 rules, empowering the Deputy Commissioner to cancel the LPC. Next paragraph. It further appears from section 79 of the Arunachal Pradesh within bracket Land Settlement and Records bracket close Act, 2000, that a revenue officer is designated as a revenue court However, as per the scheme of section 83 of the said Act, appeal against the order of the Deputy Commissioner to the government is specifically prescribed. Full stop. Next para. As the Act of 2000 does not empower the Deputy Commissioner to cancel or rescind the order passed by the said authority. And there is no corresponding rule prescribing for the procedure for cancellation of the certificate. It primarily appears that by providing a provision for appeal under section 83 of the 2000 Act, there is an ouster of implied ouster of the provision of section 21 of the General Clauses Act, 1897, which otherwise empowers an authority to amend, vary, or rescind any order. Full stop. Next para. In the further opinion of the court, once the Court of Deputy Commissioner is designated as a revenue court, unless the power of review is specifically made under the statute or the rules framed thereunder, after passing an order of granting LPC, he would become a functus officio without any power or authority to exercise power of review, so as to cancel or rescind the LPC. Next para. The court is also informed that it is a usual practice in the state of Arunachal Pradesh that the Deputy Commissioner, after adjudication, also exercises power to cancel the LPCs. Next para. Under such circumstances, the court is inclined to issue notice on the Advocate General of the state so as to address the court on the issue of empowerment of the revenue court to cancel the LPCs. Next para, it may be mentioned that the view of the court referred above is only for the purpose of formulating the issue on which notice is issued to the Advocate General without the same being construed as a final opinion of the court. Next para. The petitioner shall, the learned counsel for the petitioner shall provide extra copy of the writ petition to Ms. G. Atel, an additional senior government advocate, towards notice on the Advocate General. Next para. The notice is made returnable on, give a date after 4 weeks. 8/12/2025. Post list accordingly. Let us have a clarity on the point.
Lordship, I have a thought, Lordship, in the rule itself, there might be a.
No, there may be, that's why we said that not being able to point out. We are not saying that it is not there. So we'll examine this matter.
Since right now I'm not having it.
It's okay. But we had this issue in mind, and today we got an opportunity, and therefore we are
Yes,
joining.
very,
Even
very
both sides
helpful.
made a prayer. This must be brought to a logical conclusion.
Exactly, my lord.
Lordship,
I'll oblige.
oblige.
Give her an extra copy of the petition.
Sure,
in the course of the day.
I'll sir.
Item number 14.
Yes, no affidavit filed.
Lordship, I'm for respondent number 1, 2, and 3. Some more.
1 and 2, I'm appearing, my lord.
Or 3.
Three.
Some more time may be granted to file.
How much time? Tell us.
3 weeks, Lordship.
Hmm?
3 weeks time may be granted to file.
3 weeks time. Just a moment.
Response complete.
This in fact is the same
Yes,
issue.
same issue.
You're listing out in the same day. It was on 8/12. File an affidavit by then. All sides are represented. The learned counsel for respondent number 3 plays for and is granted 3 weeks time to file affidavit in opposition in the matter. Next, the respondent number 3 shall ensure that the affidavit is filed at least 1 day prior to the next date of, at least 2 days prior to the next date of listing. Next para. List the matter on 8/12/2025.
Item number 15.
Right.
Our Lordship, on behalf of respondent number 3, I need some time to file affidavit. It's the DC.
Respondent number
4, DC. On behalf of respondent number 2 and 5, I have already
taken a
filed.
lot of adjournments.
Oh,
Respondent number
4. For 2 and 5, we have already filed.
for 4.
Yes. 4 is the DC, Your Lordship.
Okay, both sides are represented. The border road is also not filing affidavit.
Lordship,
Who's appearing for the Union of India?
Marto Kato.
Oh, they're not parties to it.
What is?
Okay. Private respondent is there, Your Lordship, not the union.
We have received, Lordship, we have received the affidavit of the private respondent.
Where is your representation before the authorities? Where is that?
Lordship. Presentation. Lordship, it is in Annexure 9, page number 56.
50?
Annexure 9, page number 56.
56.
Yes, Lordship.
So both all sides are represented. The operation of a stone crusher unit and a hot mix plant by the respondent number 6 is projected to be hazardous for health. No, then your petition would not be maintainable. You are nowhere saying that it is causing pollution. You are merely saying that it is causing damage to the orange orchard. And you wanted compensation.
Your Lordship.
But for purpose of compensation, you have to file a suit. In a writ petition, we are not granting you compensation. And you are not alleging any that is polluting. You're not even given representation to the authorities concerned with the pollution, air pollution.
Lordship, I have served the representation to the chairman of this pollution.
Where is that?
Lordship, it is in the page 61.
61.
Yes, Lordship. Annexure 10. Lordship, here we have made the representation to the before the chairman, Pollution Control Board, Government of Arunachal Pradesh.
And also causing environmental pollution. Next paragraph. Oh, no, we can't do anything. This has to be adjourned sine die. Supreme Court has stated the order of the court. You say next will be that as it is seen that affidavit in opposition has been filed by the respondent number 6. From respondent number 2. and respondent number 5. Those for the other respondents have not filed their affidavit in opposition in the matter. Court grants a last opportunity to the other respondents to file their affidavit in opposition, failing which it shall be presumed that those respondents who are not filing the response are not contesting the claim of the petitioner, and the court would invoke the doctrine of non-traverse and proceed with the hearing of the matter. Next para. The notice of the court is drawn to the copy of order dated 13/12/2024, passed by the Supreme Court of India in petition for special leave to appeal within bracket C, bracket close, numbers 29816/2024, by which the operation of the order passed on 29/10/2024 by this court in this writ petition has been stayed till the next date of hearing. Next para. Accordingly, the learned counsel for the petitioner is at liberty to place on record any further order that has been passed by the Supreme Court of India in the matter. Next para. List the matter after 3 weeks on a date to be fixed by the registry.
Deeply obliged.
Pass over matter item number 8.
Oh, just a moment. Last order which I passed is item number
15.
There we'll have to reconsider. She has pointed out, Mrs. Ete has pointed out the power for review. She'll have to recall that order.
Yes, Doctor.
So
In item number 8, I have received the instruction just now. They are printing it out, Lordship. That's key.
no, in that earlier matter,
Yes.
in the earlier matter, you showed us that
Yes, yes.
power for review.
Yes, Lordship.
Item number 13.
Item number 13.
13.
Okay. So you want the matter to be remanded to the authorities to pass an order.
Yes, Lordship.
How much time?
Great order.
Within how much time?
Lordship, at least 30 days time maybe.
Huh?
30 days.
Okay. Which is that item number?
13.
Item number 13.
Take that order. Thank you for pointing it out.
Lordship.
It's gone there. Okay, we'll pass orders later on. The file has gone to the secretary.
Yes, Lordship.
Okay, tell her not, say not to type that order. It will be altered.
So now we'll take the pass over.
Item number 8 may be taken up after one
some
case. After some
Okay,
time.
after some time. Okay.
Bring the
Yeah, sure. Item number 16.
May I please, Your Lordship? So step was taken, the respondent number 1 to 5 has already filed affidavit in opposition. Only respondent number 6 yet to file affidavit, my lord.
6, you have not even filed the amended cost title. You have not even issued notice. Your
My lord. Implement already allowed, my lord.
we understand,
Yes,
but somebody will have to submit a amended cost title.
yes, yes.
You have not done so.
I may be given once more time for taking
How
step.
many
my lord.
days?
50, 40, sorry, 2 weeks.
2 weeks time to file amended cost title. No, you should do it today. Do it within 2 working days. Amended cost title if you.
2 working days. Okay.
Huh. Mr. Udekal and counsel for the petitioner, place for is granted 2 days time to file amended cost title. Thereafter, the matter will be listed before the court for passing appropriate orders for issuance of notice on the newly implemented respondent number 6.
Obliged.
Item number 17.
Yes, I am.
Yes.
I am praying some more time, my lord, to file affidavit opposition.
What says the representative? How much time, Mr. Parme?
3 weeks, my lord.
Despite being granted 3 weeks time by order dated 25/3/2025 and further 3 weeks time by order dated 2/7/2025, Mr. L. Parme, Leonard, standing counsel for the Agriculture Department, seeks further 3 weeks time to file affidavit in opposition in the matter. Next para. The state respondent numbers 1, 2, and 3 are put to notice that if affidavit in opposition is not filed within the time allowed, the matter would be heard without such, without such affidavit, by invoking the doctrine of non-favors, by presuming that the respondents have admitted the claim of the petitioner. Next para. The learned standing counsel for the Agriculture Department is at liberty to send the downloaded copy of this order to the respondent numbers 1, 2, and 3 to bring the order to the notice of the said respondents. Next para, list on. Give it immediately after 21 days. It will be when 1, 2, 3, 4, 5, 6, 7. List on T/12/2025. Exactly 21st days.
Interim may be considered. Interim order person.
Interim order passed earlier shall stand extended till the next date of listing.
My lord.
18.
Item number 18.
No, this is an application for coordination of 10 days, my lord.
Of
10 days, my lord.
10 days.
Yes, my lord.
You're seriously contesting it?
No, Lord, I have no objection.
Okay. Where is the file of review petition? This is fixed in review petition. Where is that file? Review petition file?
File करेगा objection.
Six hours. No, this order will not come here. This order will not come here. This order will not come here. Photocopy of the order is kept here. It will not be here. Because this is in review petition. This order is in IA. IA is there. Original order is there. Photocopy also should not be kept there.
So that's why we will be there.
No, but it's not good. Yeah, and Mr. B. Pichal, and counsel for the applicant. Also heard. For the comment, Ms. Etty will be appearing
For the state lordship.
for the state. Okay. As Mrs. G. Gotel and Ms. G. Etel and additional senior government advocate appearing for spot number 1, 2,
3, 4, 5 lordship.
3, 4, and 5.
Yes.
For Union of India, you're there.
Yes, Lordship.
And Mr.
K. Loya, Lordship.
K. Loya, Learned CGC,
Yes, Lordship.
appearing for respond was 6,
6 to 9.
6 to 9. Next, brother. By filing this interlocutory application, the applicant who has filed the connected review petition has prayed for condoning the delay of 10 days beyond the period of limitation in filing the connected review petitions. Although the learned additional senior government advocate and the learned CGC has opposed their prayer, but considering the projection made, the court is inclined to condone the delay of 10 days beyond the period of limitation in filing the connected review petition. To stop. This interlocutory application stands allowed and disposed of.
Relax, man.
Item number 19.
My lord, this
The connected
Same order.
review petition. Review is not listed today. Huh? No, reviews is not listed today.
not listed.
Not this.
Okay, then pass an order there. The connected review application shall not be listed.
Lordship,
This will go. The 19, same.
Well, same.
This is also in the same review petition.
Same.
Same, Lordship.
Okay, same order in item 19.
Lordship. Petitioner may be directed to furnish us extra copies in the review petition, Lordship.
Okay, then in the meantime, the learned counsel for the applicant shall also serve requisite extra copies of the corrected review petition to the learned additional senior government advocate and to learned CGC within 2 days. Okay, item 20.
Item number 20.
Your Lordship, 3 weeks may be granted to file our affidavit in opposition.
But you'll have to tell us why this interim order passed earlier
Yes, Your Lordship.
to stay shall not be revoked. You have not taken steps on respondent number 6.
Respondent number 6
My lord, name has been deleted from the case, ma'am.
Name of respondent number 6 has been deleted.
Yes, ma'am.
By which order? We don't know even if it is deleted by judicial order dated 11/6. You were directed to take steps.
Okay, my lord, I will get the instruction from my senior, man.
Take it because otherwise we'll revoke the interim order.
Okay, man. Till then, my lord, interim order maybe continue. ma'am.
No, not till then. You telephone him and then tell us right now why no steps has been taken. For steps, we are not adjourning the matter.
Okay, ma'am.
You get instructions right now.
Okay.
Item 20.
Item number 21 and 22.
My lord, in item 21, we have filed an interlocutory application challenging the very maintainability of the writ petition. In this case, my lord, in fact, the case of the petitioner in the main writ petition was that they are the owner of the land, and without acquiring the land and paying compensation to them, the access road to the project site is being built. This was their case. Now, my lord, it transpires that the ownership of the petitioners is being disputed by another set of people. They have filed another writ petition. State also acknowledges that there is a dispute over the ownership. If there is a dispute in the meantime, land has been acquired. Draft award has been prepared, but the state does not know whom to pay compensation. NHPC is willing to pay the compensation, but the state does not know who will get the compensation. And there is a stay, my lord, there is a stay.
For that.
So that is why, my lord, I'm challenging the maintainability because the writ petitioner could not have come saying that their land has not been acquired and money has not been paid. When they are not even the owner of the land and their ownership is being disputed, let them decide the battle in the civil court.
Okay, we issue notice then.
Fine, man. Factually, well, after perusing this interlocutory application, my lord, it appears that NHPC were in a slumber sleep. They suddenly woke up and come up with this interlocutory application to assail the maintainability, my lord. However, my lord, today I am not entering into the merit of this case.
Something. Mr. Tara will tell you something. Before coming to this, before becoming a lawyer, I was doing some tidbit business. Correct. And whenever people used to come and ask me, yes, your payment is due, I will say, yes, I can't hear you. Correct. I would shout loud of my voice, I can't hear you. So after a few yellings, the other party will go away. Huh. So
Here,
that
my
is
lord,
how-
yeah, that's it, my lord. Here the pity is there are many people, each of them are claiming they are the owner.
You want the money now, then they have woken up. Now they're asking, who are you?
No, because Lord, they have woken up for the reasons that without acquiring the land, they start.
Land has been acquired, land has been acquired.
Interesting this.
Well, in any case, my lord, today I'll not.
So that is why.
Because what my lord has just
No,
shared with
because I have
us.
to rise at 3:15.
My lord, that's why, my lord, could it be taken up on 24th? Because the project work has come to a standstill.
Okay, we
Because
should-
by the access road, the materials and the machines, heavy machines will be moved.
Okay. But Mr. P.K. Tiwari, Senior Counsel, assisted by Mr. R.L. Thungan, Learned Counsel for the applicants. Next para. By filing this interlocutory application, the applicant who is edited respondent number 6 and 7
Yes, my lord.
of in the connected writ petition have questioned the maintainability of the writ petition on the ground that the ownership of the petitioner over the land is disputed. Next para, issue notice returnable on 24/11/2025. Mr. T.T. Tara, Learned Counsel for the
1 and 2 in the IA.
opposite parties number 1 and 2, being the writ petitioners, accepts notice on behalf of the said respondents. Next, objection if any be, affidavit of objection if any be filed prior to the next date of listing. List 1, 24/11/2025.
Correct. Good.
21, 22.
Both, my lord, because there's another writ petition, they are the opposite claimants. They are saying they are the owners.
My lord, then in that, even that in the second writ petition, notice, you will have to serve the extra copies.
We will ensure because it's our urgency.
Item 22, where is that?
And also,
No order need be passed with the second writ petition. It's
No,
our
just-
urgency.
just a
We will look into that.
The 2022 is not placed before us. Just a moment.
Because there was an order of the court. Both the writ petitions were to be tagged.
We don't know.
That is why.
was 350.
You can't be in this writ petition. It has to be
No,
somebody
no, sir.
else
We are respondent.
who responded because they are your enemies.
And you have successfully created
No,
the enemy.
No, this is 26.
The state says this is the problem. Look into draft award. The state is saying.
No. This
This is WPC 352, my lord.
is 352. No, that IA is filed
I my lord in
247.
247.
That is all. No order need be passed in 352, my lord. It will come together and we will ensure that we also enter appearance in 352. It's our urgency.
No, then we record it.
But then,
This
my
is-
lord, but then
352 is item number 26. 352 is item number 26.
22, my lord.
22, my lord. It's item 22, 352.
Oh, acha. This should be here. Okay. 352. Respondent number 6, service is awaited.
Sir, we'll enter appearance. We will obtain the copy.
You are 6.
Yes.
Okay. Also, it's
Copies have not been served to us, my lord.
in this WPC,
In this.
352.
Yes, my lord.
352 is Mr. T. Garam.
Tigaram, yes.
Okay, he's not there.
He's not there.
Okay, there's no representation from the petitioner. However, for government, you will be appearing. Ms. P. Pangur and government advocate appears for respondent numbers 1 to 5. Mr. R.L. Learned Counsel for the respondent number 6 and 7 submits that he would be entering appearance for the said respondents along with Mr. P.K. Tiwari, Learned Senior Counsel. 8 and 9, Narco Lingi.
Yes, 8 and 9 is maybe.
They are the petitioners in the earlier
Eight,
notification.
okay. Although the respondent numbers 8 and 9 are being represented by their Learned Counsel, Commandant appears on call for the said respondents.
My lord, no copies have been served to us. Copy of
Next
the.
para, the Mr. T.T. Tara, Learned Counsel for the petitioner in WPC 247
247.
AP of 2025 has submitted that both the writ petitions are ordered to be taken up together. Mr. However, he has not been served with a copy of the writ petition. Full stop. The learned counsel for the petitioner shall provide a copy of the writ petition to Mr. T.T. Taravan, counsel for the petitioner in WPC 352 APO 2025 within 2 days. We just tell him, otherwise he doesn't know. 2 days, he will not even know for 20 days.
Yesterday it was listed, with a paucity of time, it could not
Right,
be
that's
taken.
okay, but tell him.
I shall convey, my lord.
Stop. This order shall be conveyed to the learned counsel for the petitioner by the learned counsel for the petitioner in WPC 247 AP of 2025. Next list on 24/11/2025. Then we have this 352 here.
Same order, same.
Same order, my lord. It will be same order.
No, here you can't serve copy on yourself.
Okay, yes.
In IA, in 350, sorry.
352, you'll have to give a copy to Mr. Garam.
Mr. Garam has to give me.
Yes.
Who is the petitioner? Okay, the same order then. Okay, okay, same order here. Exactly same order. Here. In WPC 352.
Tiwari sir is ready with the honey. So both the parties have.
That's the project.
I just told you.
With the interest of the.
I just told you there are many things I can't hear, hard of hearing. I like to tell you. Kya bola?
Money, they want the money, now we are questioning their ownership.
We don't know.
Thank you. Grateful.
We are not strictly involved in the money matters. So we can't hear many things. Mr. Panging is smiling.
Item number 23.
This item 20 is
23.
is over.
24. No, 20 is not yet over. It was passed over.
Pass over. Huh?
Yes.
Okay, that's right. Keep it here. Take those files.
20
23.
Item number 23.
There's no one there. None appears for the petitioner on call. As per office note dated 10/11/2025, service of notice on respondent number 7 is awaited. Post on list after 2 weeks. Acha, just record this. Miss Arbasa, learned government advocate, appears for respondent number
1, 2, 3, 4, and 5.
1 to 5. Okay.
Okay.
Item number 24. May I please, your lordship?
Just a moment.
24, lordship.
Yes, 24.
My lord, I have made a mistake here, in the sense that today it was to be listed, today it was to be, the prayer for interim was to be heard, but inadvertently I missed out on taking steps on respondent 5 and 6. So therefore, I'm not going to press it. But since the matter is.
You're not pressing it. You said today.
Yes, today I'm not going to, because it would be unfair now. I think the registry also might have missed out that because it's not reflected anywhere.
Just a moment.
Yes.
No, mistakes do happen.
Yes.
Once you make a statement, we are not.
On respondent 5 and 6, we're supposed to take steps.
Just a moment. Five and 6.
Yes.
No, 5 and 6, Mr. Nawam has entered appearance. You'll have to just give copies. That's why there's no.
No, lordship, there must have been a mistake because there is 5 and 6 is Secretary National Highways, Infrastructure Development Company. Mr. Nawam would be for the 1 to 4.
So the order.
So maybe.
Order is wrong then.
Yes.
Okay, Miss. And then counsel for the petitioners.
Sorry for the interruption, my lord. Since the matter is a bit urgent, can it be fixed on 26? I will take steps tomorrow itself.
Counsel for the petitioner submitted that in the last order dated 28/10/2025, the court had recorded presence, recorded acceptance of notice by Mr. R.S. Nabam, done an additional advocate general on behalf of respondent numbers 5 and 6. Post of it is submitted that the respondent numbers 5 and 6 are the authorities under the national NHIDCL, and accordingly she would be required to take steps for service of notice on them. Post on. Next para accordingly. In view of the clerical error that is crept in the order dated 28/10/2025, the court is inclined to record the presence of the Mr. R.S. Nawam, then an additional advocate general, along with Mr. P. Pango, then a government advocate, for respondent numbers 1 to 4.
1 to 4.
Next para, the petitioner shall take steps for service of notice on respondent numbers
5 and
5 and
6.
6 by
Tomorrow, Lordship, I will do it.
within 2 days for service of notice on respondent numbers 5 and 6 by email, as well as the email address is not there.
I will try to find out, Lordship.
No, without being on record, it will
Of
be very
course.
difficult.
Yes.
Shall take steps for service of notice on the respondent numbers 5 and 6 by registered post with AD. But then your service would not be complete.
Lordship, can I be allowed to take by email? I will find out the email address.
No, but first you'll have to bring it on record. Service on an address which is not there in the cost title
Yes.
have some difficulty.
Yes.
We can give you a liberty that if you bring the record address on record,
Yes.
then you take steps by email.
Lordship,
Okay.
I will try to do that by tomorrow.
Where is supposed to be? Next part, the learned counsel for the petitioner craves leave of the court to amend the cost title to bring on record the email address of respondent numbers 5 and 6 so as to enable her to take steps. Next para, the prayer is allowed. The learned counsel for the petitioner is permitted to no, don't say that. Strike that out. You say the learned counsel for the petitioner expresses some urgency in the matter. So if that be so, the court is inclined to permit the learned counsel for the petitioner to bring on record the email address of the respondent numbers 5 and 6 by submitting an amended cost title to the registry for being incorporated under the writ petition. Thereafter, the process for service of notice would be routed to the registry of the court, and thereafter notice along with the copy of the writ petition along with enclosures be served on the respondent numbers 5 and 6 through email address, if not on record. Next para, as prayed for by learned counsel for the petitioner, list on 24/11/2025.
Lordship, the prayer for interim may be heard on that day.
No,
if
first is
possible.
service.
Lordship, it as per the last order, it was to be heard today, actually.
No, I understand, but
Yes.
this is a service. We can't
Yes.
hear it.
Yes. Oblige.
Just say upon service of notice, the learned counsel for the petitioner would be at liberty to renew the prayer for interim relief.
Oblige.
Item number 25.
Right.
Yes.
The hearing matter, my lord. I understand the lordship is rising at 3:15.
3:15, there's a full court reference
I
because of
understand.
passing
I
away of
understand.
Honorable Justice
Yes.
Paran Kumar Pukar.
But so it may not be possible to complete it, but I have a proposal subject to what my learned friend says, Mr. Tapo. The dispute, we filed this petition saying that all the mail orders and the order passed by the executive authorities was without jurisdiction, so the decision passed is a nullity and cannot be executed. The dispute arose because I took a loan of 5 lakhs from my Mr. Tapo's client, and that is the dispute. I have taken the instructions from my client, subject to what my learned friend says. In fact, I earlier submit a check of 7 lakhs also. That I'm ready to do now also. The principal amount and a reasonable interest, my lord. If my learned friend can take instructions on that, then in that way, the whole matter can be sorted out also.
After so many years, I have to consult my client regarding that, but
I made a statement in the writ petition itself, man.
You can have the consultation. We'll take it up on Thursday.
that we can do.
Hmm?
Yes.
Uh, Without prejudice to the issues raised in this writ petition, Mr. D. Panging, Langan Counsel for the petitioner, has made an offer to Mr. P. Thakur on a counsel for the respondent number.
Madam. 5.
Respondent number 5. There's no number 5 here. Oh, it's a 5 is
5.
there. Okay. Huh. Respondent number 5. That the petitioner is ready to offer sum of 7 lakh.
7 lakhs.
7 lakhs or whatever your lordship deems appropriate.
No,
7 lakhs.
we're not suggesting anything.
Okay.
It's your offer to him.
Yes, 7 I have already offered earlier also.
7 lakh.
Principal was 5.
For
8
settlement of all the disputes outside the court. Next para. Mr. The Land Council for respondent 5 prays for some time to obtain instructions. Next para. Ms. P. Pangul and the government advocate is present for the respondent numbers 1 to 4. Next para. As prayed for, list on 1311. Possible?
Yes, ma'am.
1311 2025.
Oh, nice.
Passover matter, item number 8.
Lordship, actually what they have told me is that the incumbent who was there, he prepared everything, and before sending this to us, that she left us there. The new incumbent has come now. So they have provided me the instruction. I will say if I am given time to file it. What they are saying is, Lordship, $3,490.45 was only acquired from her. The other square meters, acres she's showing that haven't been acquired, Lordship. And even in her.
Just a moment.
Lordship. Para por Lordship. Also annexer 1, Lordship.
Just. Okay, we'll be allowing 2 weeks time to file your affidavit.
Lordship.
Lordship, in documents of this state also, it is already clearly mentioned that 17,900 square meter Mobibama.
No.
Your Honor, that in my Your Honor,
Where is that page?
Your Honor, page number 33.
33.
Yes, Your Honor. In my petition, Your Honor. And moreover, LPC is also there. Your Honor, in the whereas, page number 33, whereas, and given below is 5% that who has land possession certificate. And this is inclusion under the land that acquired by the last one, 5, Mobile 17,900, Your Honor.
No, this, you look at that, whereas as per estimate cost sheet by our office, the acquisition of private land measuring so-and-so land possession certificate.
And Your Honor,
5 numbers of owner were submitted to this office as per detail. In addition to joint willingness, certificate of only 7 persons were submitted with the so-and-so.
exactly,
So this
Your
is not a land acquired.
Your Honor, that then Your Honor, one deposition of the amount deposited by land department, Your Honor, that
38 lakh 39,495 to you.
yes, Your Honor. Then 24 level 2017 by DC dealer so 5 lakhs 50,000. This is when I sought for the remaining amount. Then they already deposited 5 lakhs, Your Honor, because there is clear cut land that measuring 17,900, Your Honor. And Your Honor, this is land possession certificate which has been issued by. This is also clearly mentioned that 17,900, Your Honor. This may be case that they have dispersed
You
the.
see, can we order compensation without there being a land acquisition merely because somebody is possessing it?
Your Honor, they have taken the position, man.
They may have taken the position. You ask for the land back.
Your Honor.
We can't issue a rate for compulsory acquisition of land if the government does not want it.
Your Honor, when we ask for this problem, then they pay advance, Your Honor. This is the fact. Because when I this request for the land, they have taken the position. Then they pay 5 lakhs 50,000 as advance, Your Honor. This is this has to be denied by the opposite.
Even if they pay, it's a dole out. Doesn't create an interest on the balance land if there is no acquisition.
Your Honor, that is the reason that.
They can't be compulsory. It's my own order in the principal seat.
Your Honor,
there can't be an order of compulsory land acquisition. Or petition will be dismissed.
Your Honor, that I have a very clear this.
No, we have understood it. That's why we took some time to understand the documents produced by the government advocate. If you want an affidavit to come, we'll adjourn the matter. If you want the matter to be heard, we are ready for hearing.
Your Honor.
Make your submissions.
Your Honor, actually,
we'll be relying on the documents submitted by Mr. Day.
And Your Honor, one case is that the person who does not donated the land, who does not have, they are also included in this. There will be some.
We are not bothered with others. It's the government's money they want to dole out. Let them dole out. If we have a PIL, then we'll consider that payment to illegal persons. But
Your
now,
Honor,
as on date.
Actually, Your Honor, let them file affidavit, Your Honor.
And
this reply has to be filed very earlier. Now, lingering this case and last stage.
Please don't pass comments. We told you that we are ready to hear the matter.
Your Honor.
It is for you to start arguing.
Your Honor.
We are not saying that the court is adjourning the matter because of that affidavit. We are prepared to take up the matter.
Your Honor. Then after 2 weeks, Your Honor.
Then we are not shying away from doing our work. Every day we have to hear the matters. If not your matter, somebody else's matter would be taken up. Correct?
Your Honor.
Then we are not shying away with the work. But once the materials are there, we are giving only 2 weeks time to the respondents to file the affidavit. Land acquisition payment and compensation for illegal holding are two different things, two different concepts. Both sides are represented. Yes. Mr. Kato is also there.
Yes.
Right, all sides are represented. Ms. G. Hete, Learned Government Advocate, has produced copy of Pharaoh's comments received by the state respondents in this matter by the Deputy Commissioner, West Siang District, Ado in the matter. Full stop. In that view of the matter, despite last opportunity being granted by order dated 21/8/2025, one further chance is given to the state respondents to file the affidavit in opposition in the matter, during which, in terms of order dated 21/8/2025, the matter shall be taken up for final consideration without the affidavit of the state respondents. Next list on, give date after 2 weeks.
2 weeks will be set.
Third, P12.
P12/2025, the affidavit shall be filed at least 1 day prior to the next date of listing.
Lordship, last order could not comply because of the change of the incumbent, Lordship. Last Honorable Court's order could not be complied because of the change of the incumbent, Lordship. So.
No, whatever we are, since you have produced this, you have
Yes.
saved yourself an opportunity to file an affidavit, otherwise
Yes.
we would have rejected it. To meet, you take back those instructions.
Yes.
Yes.
Pass over matter item number 20.
Apologize me, my lord. Apologize me, my lord. I and my senior had a miscommunication, man. Respondent number 6, maybe my lord, his name may be strike off from the petition, man.
Struck off,
Yes.
okay. Upon instructions, Mr.
The other man.
B.
The other. My name is not reflected in the court this month.
Mr. D.
The other.
A.
The other. ADO. Other.
ADO, Adol Learned Council, appearing on instructions of Ms. Ann Dengen and counsel for the petitioner, has prayed for striking out the name of respondent number 6 from the area of parties. The Mr. Vairi Ram, the government advocate, is present. On the ground that the person added as respondent number 6 being, namely, Sri Taken TAKEN, expert Palong PALONG, General Secretary, Kayang KAYING, Kayang Welfare Society is neither necessary or relevant party to this writ petition. And then it will come, the Mr. Vaidinam, and government advocate is present. Next part, the prayer is allowed. The respondent number 6 shall be struck off from the area of parties. The registry shall do the necessary correction in the cost title. Next para. The state shall file their affidavit in opposition for my advised within the next date of listing. Next para list after how much time?
3 weeks, Your Lordship.
3 weeks.
So, my lord, there is an interim order that.
Okay. Interim order passed to list and is extended till the next date of listing.
Yes, Your Lordship.